everybody. So mine ties in quite nicely with what Matt's just talked about. I'm an IP lawyer. So if you ever do innovation, research and development, anything like that, then hopefully you'll be generating new intellectual property. So what I'm going to do is talk through quite quickly what intellectual property is, why it's important, how you can protect it, etc. Just a bit of background on me. So I work for Shakespeare Martineau. We're quite new to Sheffield. We've got offices all over the UK, and our Sheffield office is now growing. So I'm quite new. Well, I say new. I've been here for about 2 years now. I specialise in IP. I've done it for about 10 years, and I work with companies right through from the startup all the way through to exit, and all different shapes, sizes, all different technologies. So what is intellectual property? So essentially, intellectual property can be quite hard for people to understand because it's not a tangible thing. You can't hold it, you can't see it. But you need to think of it, it's just like any other property, right? So if you own a house, for example, you can buy it, sell it, lease it. And intellectual property is just the same. It's a property right that you hold, and it does have value. The thing is, as I say, it's intangible, and it protects what essentially are creations of the mind. And I say that in a way that I don't mean anything that has to be creative, as in I don't know, artistic or something like that. It also protects a lot of technical stuff. And the reason why IP is really important is because essentially it gives you the right to use something to the exclusion of other people. So if you think about using a brand, using an invention, if you've got intellectual property, then you can use that and stop other people from using it, which will obviously distinguish you in the market. So I'll try and run through this slide really quickly. I was at Sheffield Tech Park a couple of months ago, and I ran through the slide, and it took literally about half an hour. So if you have any questions, give me a shout, but I'm happy to run through it in a bit more detail. But this is basically what types of IP do we have in the UK. You've probably heard of most of these, but I'm just going to run through really quickly what they are. So Matt talked about patents. Patents protect inventions. So an invention is something which is new and involves an inventive step over what went before. So everything really that Matt was talking about, if you're going to improve on the technology and move it forward in some way, then you might have something that is protected by a patent. It protects products and processes. And the main things really to say about, well, there's two main things to say about patents. One is there's a kind of a myth, a long-standing myth that you can't patent software, which is not quite correct. So if you do have software, if you've developed some new software and you're thinking, oh, I can't patent this, please talk to somebody about it. So you talk to me. I don't file patents, but I know patent attorneys who do, and I know very good ones who are able to get protection for software. So that's the first thing. Second thing is this requirement of new is really strict. So just make sure that if you do have an invention, if you're working on anything, keep it secret, keep it confidential. If you're going to talk to anybody about it, make sure that you use a non-disclosure agreement. You can talk to somebody like me about it because I have obligations of confidentiality. But just to let you know how strict this requirement is. So we worked on a case, it was just pre-COVID, so a couple of years ago, and we were acting for a defendant in a case who was being sued by, our client was a farmer, and he was being sued by another farmer. And it was basically machinery that, I think it's called, I didn't work on this case, by the way. I think it's called strip tillage, so it's basically a way of ploughing and sowing fields with a new kind of machinery. And these are big, dragged along by a tractor. So this other farmer had a patent for their bit of machinery, and you have a filing date for your patent. It's called the priority date, and that date's really, really important. We wanted to knock out the patent, because if we knocked out the patent, then we didn't infringe it, because it didn't exist anymore. So we found out that my colleague found out that they'd done testing with this particular tractor on a field before they filed their patent. So it's a couple of months beforehand. we've managed to find some old articles somewhere on the internet where they tested it on a field. And I think the field was really far away. I didn't go, but my colleague was convinced if you drove out to this field, you'd be able to identify a public footpath. And from the public footpath, you'd be able to see enough of the field to see a big tractor dragging around a big piece of machinery if it was being tested. So we won that case because we managed to go, I think it was down in Somerset somewhere, we managed to go to the field, we managed to take photographs of the field empty, and show it to a judge and said, look, if a tractor's being dragged around this field, being tested, then it's not new anymore because it's available to the public, people can see it. And that's how strict the requirement is. So they lost their patent because they tested it out in the open before they filed their patent. So it is incredibly strict. There's also an old saying that even if your idea is in a book in a library that's never been taken out or read, it's still disclosed to the public. So if you have the moral of the story is if you have any invention, just make sure you keep it secret and you talk to somebody like me. Otherwise it might not be valid. Trademarks protect brands. I love trademarks and I love brands. I think they're really, really interesting because a brand is what you present to the public. Your brand is what you essentially it's giving your company a personality. So things like product names, logos, your company name, for example, all of those might be trademark protectable. The reason why a trademark is important is because it's an indicator to the public of the origin of a product or service. So when you see Shakespeare Martineau, for example, you know where the product or service is coming from. Another example, I think a great brand is the Nike brand. It does a lot sort of out in the market with, it's not just the products that they sell, it's what they do in general, what the company stands for, what the values are. So trademarks are really important, and like I said, I find them quite interesting. Design rights protect the appearance of an object. So really famous design right cases are Apple iPad and Samsung had a case because they had the tablet when they first came out, the iPad and the Samsung tablet. Apple suits Samsung. So it's all about what something looks like. Copyright. When you think of copyright, think of things like literature and the arts and things like that. So it protects books, works of art, musicals, things like that. But also think about software. Because I was saying before, you might get a patent for a software, but even if you don't, the source code that makes up your software is actually protectable as a literary work, which is a bit bizarre. And one day we might come up with a better way of protecting software if it's not patentable. But at the minute, it's protectable as a literary work. And then finally, trade secrets. It's something that it's not technically an intellectual property right, but we call it an intellectual property right. Essentially, it's something that's valuable to your business that is kept secret, and that is how it keeps its value. So you see trade secrets a lot in certain types of businesses, but one that you'll see a lot is in the sort of food and drink sector. So think about KFC, Coca-Cola, their whole recipe and their whole brand is protected by trade secrets. So it does work. So why is it valuable? It's valuable because you probably see, if you've ever watched Dragon's Den, one of the first things that they'll ask somebody is, what kind of protection do you have? If I invest in you, what's to stop somebody else competing and basically taking a huge share of the market? So intellectual property gives you an advantage over your competitors. It gives you a unique monopoly in the market. And it depends on how strong your IP protection is as to how strong your monopoly is. But it's something that's still very worth thinking about. It also builds consumer trust. So it's, as I say, it's not just the brand that builds trust. It's things like having a design that's people know. If they go back to you, they're going to get a good solid design. They're going to get a good solid product. If you think about Dyson, for example, when that came out, the bagless vacuum cleaner, all of their products are built on this really interesting brand and portfolio of patents, so you know what you're getting. And then also contributes towards intellectual advancement, everything that Matt was just saying just now. So essentially, we do it this way, and what I love about my clients is they are disrupting the norm. They're taking something that was always done this way and changing it. And I find that really satisfying talking to my clients about essentially how they are contributing towards the state of the art. So what can you do with IP? You can use it or sell it. They're sort of the main things that people will think about. So by use it, I mean, you've got an invention, you make the product and you put it on the market. Selling it, you could have a patent, you could invent something. I work with clients who invent stuff and then sell the patent on because they don't really want to have to bring the product to market. So there are two examples, but the bottom two, licensing and collaboration, they're ones that I find much more interesting, and actually it happens much more often. So licensing essentially is you keep hold of your IP rights and you allow somebody else to use it. So, for example, if I have a patent and I've got patents in the US and the UK, I might just want to exploit the UK market. That's my bag. I know I can do that well, but I might license my patent in the US for somebody else who knows that market better to market the product over there. That's just one example of licensing. Collaboration is something that is sort of trendy at the minute. On the radio, I always hear about people collaborating. I think it's basically musicians working on products, and it's a similar kind of thing. Collaboration is all about where two people who have intellectual property come together on a project to use what they know and build something new. So with collaboration, you essentially have background IP, and you work together on a project to create foreground IP. And a collaboration agreement is a document which will essentially say, you own your bit, we own our bit, and then who's going to own the bit that is generated, the new stuff, the valuable stuff, and how we're going to make money from it. How do you protect IP? Some IP is registrable, so patents, trademarks, and registered designs. If you can register IP, please do so. It really does make life a lot easier if you do have an infringement problem. So registering IP, you can speak to a patent attorney or trademark attorney. Again, we've got really good contacts, and we'll be able to put you in touch with the right person. Obviously, all of those come at a cost, but it's still worth the investment to make sure you get it registered if you can. Protecting IP also, you have to actually own it. So I'll come on very quickly at the end to a couple of case studies, and one of them touches on ownership of IP. The golden rule really is that the creator of something will own the IP in it, and the only exception to that is if you're an employee creating something in the course of your employment. In that case, your employer almost certainly will own the IP that you generate. But if you create something, an example where people slip up quite often is using third-party software developers. So you might have a new product, have a software developer, they develop some software for you and you don't get an assignment of your IP into your company. That's when you can run into problems. You also need to please the market. Just because you have a patent doesn't stop anybody else from copying it. So you have to keep your eye on the market, and you have to enforce your patent, basically sue somebody if somebody's copying, and keeping records, unregistered rights like copyright, unregistered design rights, trade secrets. Make sure you keep a record so you can prove you've got sort of evidence of your ownership. Oh God, sorry. Didn't know that. So this is a business life cycle. So in Shakespeare Martineau, we do a lot with, we work a lot with fast growth companies. I call them startups. We're supposed to call them fast growth companies, but so we're working with companies at this sort of stage, and to me that's really exciting. I love working with startups. And essentially, when you're starting up a new business, you're generating loads of IP, and I don't think many people really know that that's what they're doing. So you'll be generating a brand, new products, new services. A lot of products now are apps, so you'll be developing code for that. So IP is really important at the beginning. It's really important to make sure the company owns it and protects it. And then as you go through the business cycle, so growth phase, using IP when you're attracting investment, first thing an investor's going to ask, like the dragons, is do you own the IP? And they'll do their due diligence on that. Expansion, looking at IP in other markets. If you're expanding, for example, into foreign markets, do you have IP protection there? Some people assume that if you have it in the UK or Europe, you automatically have it elsewhere, and that's not necessarily the case. And then on exit, if you exit, you will leave the IP most certainly in the company, which means there will be some restrictions on your future use if you want to go into something similar going forwards. IP resources that are available. There's loads of resources. So I know I've run through everything really, really quickly, and you can always give me a call if ever you have a question on IP, but these resources are just a few that are out there that are really great. The Intellectual Property Office website and the office is based in Wales is surprisingly useful for a government-run organisation. It is incredibly, the website's really useful, the people on the end of the phone are really useful, they know a lot about IP, and they're sort of really passionate about how to help you to protect it. So go on their website if you want to find out a little bit more, loads of free resources there. I also run a pro bono drop-in clinic with Sheffield Central Library, and I also do one at Sheffield Technology Park. Essentially, half-hour quick chat with me about IP, how can we protect it, and what do you need to think about. We also do a pro bono session at Business Sheffield as well. So what to think about, essentially condensing everything I've said into 3 very quick bullet points. Contracts, get your contracts in place. So if somebody else is involved in developing IP, make sure that you have a contract with them that says that the IP is owned by your company and not by them. Registration, if you can register your rights, then do it. It's a really good investment. And keep records. So if you're developing something, R&D, anything like that, keep a written record of it, even if you're protecting it as a trade secret. Make sure you've got the records kept in a confidential way. Really quick case study. This is the one I was talking about earlier. So one of my first cases that I ever worked on was a bit.
Here's what I found.
Sorry. It was a really tricky one because we worked with a couple of guys. They made a really, really interesting product. It was driven by software that was developed by a third party, and then it was all on a handshake gentleman's agreement. So these guys developed software. The product was really successful. It was sold. Our guys wanted investment. And then when the investor looked at their company, they realised we don't own the software because your developers own it. You might have a license to it at best. So we had a whole big dispute then about trying to get the ownership of the software into our client's company. And obviously the investors got a little bit freaked out at that point. Another example is I've got a client that I work for, didn't have any registered trademarks, but somebody, online infringement is quite tricky. So Amazon marketplaces and those kind of things. Somebody was infringing their trademarks, and they had to rely on unregistered rights and passing off as opposed to registered trademarks. That's just basically, it costs a lot more to do it, takes a lot more time, it's a bit more of a headache. So if you can register your trademarks, make sure you register them. And that's it from me.